Yes,
Lordship, I beg to mention item number 8 and 10.
8 and 10.
Yes.
Why?
Leading counsel is out of the station.
You are for petitioner.
Yeah, no, respondent. Both of the 10.
I'm for petitioner. Okay. On the prayer of Mr.
2 weeks.
Your name, please. On the prayer of Mr. Swain, Land Council, appearing on behalf of Mr. R. Sonar, Land Council, for the respondents. And prayer not being objected to by the Land Council to the petitioner, list this matter after 4 weeks.
Yes.
Then 18, 10.
10 also.
Same word.
Thank you.
Your Lordship, I beg to mention item number 26.
26.
We are petitioning hearing. The leading counsel is out of session due to some personal difficulties.
On
The
the
matter
prayer
may
of
be adjourned for 2
your
weeks.
petitioner.
Yes.
Petitioner.
Yes, Your Lordship.
On the prayer of Land Council, Mr. So-and-so. List this matter after 4 weeks.
Oblige, Your Lordship. Your Lordship, there is interim hearing that may be continued.
Interim hearing.
Yes, Your Lordship.
Interim order was earlier said continue.
Much obliged.
What do you mean by interim hearing?
Interim order hearing.
Yes. Say interim order.
I'd like to mention item number 16.
16. Yes.
Yes, Your Honor. This matter may be fixed on Friday.
Why Friday?
This Friday, Your Honor.
Why?
Our counsel is out of station. He will be available on Friday.
On the prayer, Mr. Hagetai.
Yes, Your Honor.
Land Council would list this matter after a week. After a week.
After a week. Oh, and interim may be continued, Your Honor.
Interim order plus earlier.
Oblige.
Your Honor, beg to mention item number 15
Yes.
on behalf of N. Taje.
We'll see. It is 4 orders.
Yeah.
Just check it. What's it? 15. Item 15. We have not taken steps.
Respondent number 6 is yet to file affidavit.
You have not taken steps.
Yes, I am for the petitioner.
That's what I'm saying. No steps for issuance of notice of respondent number 6. We have not taken steps.
Yes,
So
respondent number 6 is yet to file affidavit.
you have to first take steps, sir,
Okay.
for issue of notice. Notice has to be served on him. Then only filing of affidavit comes. Right.
Okay.
Office note dated 16/11/2024 indicates that, reflects that the petitioner has not taken steps for notice upon respondent number 6. This stuff. Further 3 weeks time, further 2 days time is granted to the Land Council for the petitioner to take steps for service of notice upon respondent number 6. List after 3 weeks. What is this, sir? If the matter was something, I mean, the issue which was taken up in the earlier proceedings, if it's a different land or different issue, I mean, subject, why records is required?
Now, my lord, petition is directed against an order passed on a trial court,
Yes.
rejecting our prayer under order 13 rule 10, whereby we made a prayer to call the records of a particular civil dispute from the office of the deputy commissioner.
That's what I'm saying. If it was something different, why records should be called?
Now, my lord,
Unnecessary.
now, I'll just follow that. Now, my lord, what, just a brief.
We'll just issue notice, that's
So, my
all.
lord, I need to, because my lord, 29th matter is the trial is fixed for 29th.
Doesn't matter.
No,
We're
that-
not passing any orders, sir.
The pilot will kindly we'll tell you how to please that case, but thereafter, my lord, subject.
Well, issue notice, we'll see. On,
Now, my lord,
on returnable, that we'll see.
Now, my lord, the problem here is this, my lord, because, my lord, we are saying that this is the same plot of land. They are saying it is different plot of land. Whether it is the same plot of land or a different plot of land is a tribal issue, my lord.
Yes.
The question is that if the original records are not called for, my lord, we cannot cross their witness effectively. Because we'll have to confront them with the documents which are there in the record. My lord will kindly see their own pleading. I'll just show my prima facie, I will demonstrate that, my lord, my lord, subject to correction, my lord. I am making an application for calling of the record. They are opposing that application. The very purpose of opposing is that they know that once the record comes, they will be exposed.
Where's the order?
Yes, my lord, will kindly see the impugned order which is passed at page number 188. The IA number such and such has been filed by the defendant taking the plea that the dispute pertaining to the suit land has already attained finality.
Come to page 190.
One?
Last para.
190.
Yes.
Now, my lord, 190, my lord, will kindly see, before 190, my lord, one page, I must take the lordship to the list of documents which you have filed, because the learned court is completely silent regarding the other documents. My lord, may kindly come to page number
You just
seven-
read, you just
70,
read the 190,
190.
two paragraphs.
Two paragraphs. Heard both learned counsel, I have perused the application which shows that the prayer under order 13 rule 10 CPC has been made by the applicant defendant for document number A to M. So my prayer is for document number A to M, which has been annexed in WS. The respondent re-entered in their objection. Now they file an objection. In their
You read,
objection.
sir, you read.
Pardon?
Go on, read it.
Yes.
Hopefully, we all of us understand the English.
No,
English
absolutely. I
language.
was just trying to emphasize on. The respondent plaintiff in their objection have not disputed the credibility of any of these documents. Their main contention is that the suit land in document A to M, which pertains to the records in civil dispute number such and such, and the order passed by the Honorable High Court affirming the decision of the learned DC Pasigat, is for the land situated at 2 mile area, Pasigat, and it is nowhere connected to the present dispute land, which is located at 3 mile area. It is their submission. Now, the court. Furthermore, it appears pertinent to take note that the documents from F to M. Now, my lord, the initial documents were A to M, now F, A, B, C, D, gone. F to M of the WS are judgments of the learned DC Pasigat and the Honorable Guwahati High Court in CRP number such and such, which are certified copies. And in all these decisions, the kabang of such and such, such and such, and such and such are already mentioned. In fact, the CRP number such and such was a result of order passed by the DC Pasigat on such and such. As all these documents number A to M are official records of decision passed by the village authority, the DC Pasigat and the Honorable High Court certified copy of this document are admissible under section 76 of the Indian Evidence Act, which are already annexed in the WS. This court does not see any need to call for the original document. These official records being public documents, certified copies of these documents. My lord, this is an incomplete sentence anyways. Now, my lord, will see the learned judge is factually wrong here. She says, as all these documents number A to M are official records. Now, my lord, will see the documents, the list of the documents. Page number 73.
Yes, what do you say?
Page.
If your lordship finds their application, madam, their application, their pleadings are that for A to M, they want to prove these documents. However, the prayer is to call for the entire record of that civil dispute. Now, the provision under which they have filed this application, that itself doesn't empower it, because that provision comes only before the issues are framed. Once the issues are, your lordship will appreciate one thing, nobody can be brought to surprise in a court, The court has framed the issues based on the documents that was produced by them in the WS. And this A to M, these are the documents which was produced by them at this stage when the document stage was there. And these documents, my lord, if your lordship sees the A to M, these are all official public documents. In fact, my lord, the learned civil judge has given an opportunity to prove this document by way of a secondary evidence. Whereas there was no application. If somebody should have been aggrieved, it should have been me. But we are not disputing that because otherwise also, my lord, now the stage is we have filed evidence for 32 witnesses. The cross-examination has not started. The outcome of this application, even if your lordship decides in their favor, the outcome of application will only come after my evidence is completed. So at this stage, what I play, issue notice. Staying the proceeding of the title suit.
Yes.
But that's the intent of prolonging the litigation. And there is a
Heard, mister.
My lord, this is the law, submission on law, just
It's
one
okay.
paragraph.
We'll see, we'll see.
And
We'll just
one
issue
paragraph
notice.
I show, my lord, this is an absolutely incorrect submission made. My lord, will kindly see this para 8 of this judgment. Firstly, we have filed this application, my lord, why they are scared of the record? How they are going to be prejudiced with the record?
that's what not.
They are not prejudiced in any way.
My lord is deciding
Because
227, my
they will
lord.
not- Kindly see para 8, because they are saying basically that we have filed it at the initial stage, even before, immediately after framing of the issue. My lord, will kindly see paragraph 12 of this order passed by our High Court. This is a settled law, my lord, that an application under order 13 rule 10 can be made at any stage, and we have made at the threshold immediately after framing of issue. My lord, I'll just read para 12. Order 13 rule 10 CPC does not provide that the application to call for the records cannot be filed at the hearing stage of the suit. It speaks of hearing. In the application filed by the petitioner defendant under order 13 rule 10 CPC, no doubt it has not been stated as to why he could not file the same application at the stage when the suit was fixed for taking necessary steps before preemptory hearing or before examination of the plaintiff witness. The same application also does not contain any statement why he could not obtain the certified copy of the record or whether he has applied for the same. Normally, such application under order 13 rule 10 is required to be filed at the stage when the suit is fixed for necessary steps before preemptory hearing, and we have exactly done the same. But it is not that an application filed by any of the parties to the suit thereafter cannot be considered, and no order to call for the records can be passed by the court. Even if such record is necessary for adjudication of the controversy between the parties effectively and completely, and it is necessary for the purpose of justice. On the ground that there is no statement in such application that the authenticated copy of the record sought to be called for or part of it could not be obtained without unreasonable delay or expense, the court, even in absence of such statement, can call for the records or any part thereof if it is necessary for the purpose of purpose of justice. Now, my lord, their entire contention before the learned trial court, they are trying to create, my lord, a difference between the two lands. My lord, just one page will, my lord, clarify the issue. My lord, will kindly come to the suit they have filed.
Sir, we are not dismissing your petition. What is doing notice?
No,
Here
my
you
lord, my hesitation is this, my lord, kindly, my lord, will kindly bear with me.
no prejudicial cause.
My lord, will kindly bear, on 29th is the day fixed for cross-examination of this witness. The original records are not in the court, my lord.
You are relying some documents. You want that some document has to be brought in.
That documents for the
How- how-
purpose
how-
of refreshing
how-
the memory, it can be
How
done.
it will affect the cross-examination?
Exactly, my lord. I don't understand this argument.
How it is affecting. Now, suppose a witness.
You explain later.
My lord.
On next date, you explain.
My lord,
Yes.
Today we are issuing notice.
So, my lord, then.
Heard Mr. Ambitious.
It has to, my lord, kindly, my lord, before 29, because I'll be highly prejudiced, I'll not be able to cross-examination them by confronting the documents. The documents are not before, how can I confront them with their signature?
My lord, will kindly
They
see
will
page
not-
159, my lord.
They will not be.
Why they want to,
Stop the record, because they know once the record is before the court, their case is gone. I can show from their own pleading that, my lord, one affidavit which they
Heard
have
Mr. M. Biswas.
only before 29.
M. Biswas.
Yes.
Learned counsel for the petitioner. By filing this revision petition under Article 227 of the Constitution of India, the petitioner had put to challenge the order dated 27/09/2024 passed by the Civil Judge Senior Udin Bekar Senior Division Pasigat in IN number 02 of 2024, arising out of title suit number 24 of 2021, by which the application under Order 13 Rule 10 CPC filed by the petitioner has been rejected. Mr.
be cautious, my lord.
B. Kaushik, learned counsel
I'm on caveat.
Huh?
I'm on caveat.
You just, in that thing. Accept notice on behalf of respondent number,
All respondents, my lord.
for all the respondents. Therefore, no formal notice need be served. List the matter. On,
If your lordship is passing any interim, then not with the post 29, otherwise.
In fact, my lord, there is a-
I will not be able to pause them, my lord, without the documents.
Well, let him make an application before the civil
let
court
us-
about
let us
this.
do a take. Let's fix it in 28.
28.
We will dispose of the matter.
My lord.
28.
28.
Correct. 28. List the matter on 28, 28, 11, 20.
Can it be 27, my lord?
27.
27, but 28, 29 we'll have our better day.
Caveat in caveat, you write, heard so and so, so. Caveat is then in church.
27.
You decide.
Yes, my friend is.
Otherwise also, my lord.
At least for fixing, they don't,
Yes, yes.
don't quarrel.
I'm
Don't
not-
quarrel.
In fact, there is an order from this court, my lord, where their injunction order was modified, and that this honorable court directed the civil court to decide this
We'll
suit within
reject-
1
We'll-
year.
We'll reject
Yes.
it, reject it on 28.
Hmm.
Let the matter, we fix on 28 for
Fine.
rejection of the petition after hearing Mr. M. Biswas.
I'm highly grateful, my lord.
This is just not right.
Such applications invariably are allowed, my lord, in all citizens, because at the end
I
of the
got
day, it is just calling for.
But it's
Thank
the
you.
mischief which they wanted to play.
Thank you, sir.
Obliged.
Mr. M. Doji, learned counsel for the applicant. This is an application for why 439? Criminal Procedure Code.
But this case is registered prior to the commencement of the
This court has disagreed with the judgment of the coordinate bench. And recently, the division bench has answered the reference in affirmative. File a press petition. Go to the judgment.
Yes.
Division bench.
earlier also.
According to you, this case was registered prior to 1/7/2023,
Yes,
2024.
yes,
Therefore, you have filed this petition under 439.
yes.
That law is no longer, I mean, it has been settled now by division bench. Even if the case is registered before 1/7/2024, if the petition is filed, should be in the new act.
In this case, I may be. Well,
Withdraw and go through and file fresh.
Yes.
On the prayer of Mr. M. Doji, learned counsel for the applicant. No, you just said, Mr. M. Doji, learned counsel for the applicant submits that the application, the present application has been filed under 439 of CRPC 1973. Please, within bracket, now repeat bracket close. As the case was registered prior to the coming into force of the new act. Mr. Bhawbar. He submits that in view of the order of the Honorable Division Bench, this court, he may be allowed to withdraw the petition with a liberty to file afresh. Mr. Next. Where for withdrawal is accepted, Mr. Accordingly, the application, the present the application is allowed to be withdrawn with a liberty as spread for.
all right, hold on.
But I'm extremely sorry, my lord. We have decided, but can it be on 4th of December? Because my brother and me both having some difficulty on 4th of December. Both of us has agreed. He's also there.
You are scared.
Uh,
You are scared.
No, I'm not scared.
Are you prejudging that your petition will be dismissed?
No, not that, my lord, because on 29th we will have to go to.
List the matter on 20th
4th,
for
4th December. 4th of December.
28th,
4th, because my lord, 28th will be there.
when the revision petition of the Mr. Biswas shall be allowed after hearing.
But let it be on 4th.
Make it
4th,
4th.
4th. And we'll get to that.
Yes, sir. What is this?
The quashing petition yours.
Or Mr. We'll call for the scan copy. Yes,
Yes, this is a joint petition.
yes.
They have arrived into settlement.
Hmm.
And offense is
Heard Mr. J.G. learned counsel to the petitioners. And also, no, petitioners, list of, this is the application and the section. Why you are adamant to file a petition in the all act which has been already repealed?
Lordship, in under bracket, I have mentioned.
Why you are adamant?
Lordship will file from now on. So bit of confusion, so this we have inserted in under bracket.
It's really uncanny.
We'll correct it, Lord.
This is an application under section 528 of BNSS 2023. Framework. Washment of. What is this?
Junk.
FIR.
Junk PS case, Lordship. GR case number 8 of 2020.
GR case number 08 of 2023 under section 457 oblique 380 of IPC pending before the learned judicial magistrate first class, Tawang, on the basis of settlement.
Yes, settled.
Just call for the scanned copy of the trial court reports from the magistrate, from the learned judicial magistrate, from the court of learned judicial magistrate first class Tawang. That's all.
Lordship, proceeding may be stated till
Next week.
disposal. Yes.
Pending Mr. T. G. Thadu, learned additional PP. Appears for the state, learned additional PP. Appears for the state. Mr. Pending production of trial court record. Further proceedings of the GR case number 08 of 2024. Is it 24, 23?
It's 23, Lordship.
23 shall remain.
Your Lordship, may I pray?
Suspended.
This is a case of stolen of holy books of the Buddhists. And prosecutors, this complainant, now only charge was only framed. He may be examined at least, complainant. Complainant may be examined. That he willingly withdraw on behalf of the entire community. Just he put his signature on the settlement.
Okay, we'll see. On next day.
Yes, he may be.
List the matter after 4 weeks. We'll see.
Right.
Sir, you may be correct. What's the offense?
The offense is 376, 313, and 417 of IPC, Lordship.
You are trying to play safe.
No, Lordship,
Why you need to mention 482 now?
Lordship, I have mentioned 528, but 482 refill, Lordship.
It's
From next time, Lordship,
It's
I'll correct.
either 482 or 528. That's all.
Yes, Lordship.
Or Mr. Or you learned counsel for the petition. This is an application for under application under section 422, same, huh? BNSS 2023. Praying for enforcement of criminal proceedings. Being sessions case number 08 of 2022. And section 376, 313, 417 of IPC. Pending before the sessions judge UPR.
Yes, Lordship.
Call for the scanned copy of the third court reports.
A notice may be issued, Lordship, upon respondent.
MS, huh?
Notice may be issued upon respondent number 2, Lordship.
MS L Hage learning additional PP appears for the state. Issue notice to the respondent number 2. Returnable 3 weeks. Returnable by 3 weeks. Then counsel for the petitioners to take steps for service of notice upon respondent number 2 within 2 days from today.
Lordship, I have an entry, Lordship. Lordship,
376.
since the trial is under already.
Sir, 376, no.
Lordship, there is no case at all. Since
We'll see.
the board,
That's why
the
we're
victim and the
that's why
accused
we're
person
issuing-
were a husband and wife for 12 years.
Sir,
Lordship.
that's why we're issuing notice.
Lordship,
And
in-
calling for the
yeah.
records.
Yes, in
That's
a-
why.
Lordship,
We'll see,
during,
we'll see.
Lordship, during,
376, no.
Lordship, during cross-examination of the victim, there was no case made at all.
It's good for
Lordship.
you. Keep it for
Lordship,
yours-
the
keep it for yourself for the next hearing.
Lordship, my interim prayer may be considered on next year. Lordship.
No interim. It's always there. You may
Lordship,
review.
there is no case
You may-
at all, Lordship.
We'll see. We'll see the records. 376.
That is there, Lordship, but there are so many judgment of apex court, Lordship.
There are so many
Wherein-
judgments against you also.
That is there, Lordship, but I will try to satisfy this honorable court, Lordship.
Yes, you satisfy next date, on next date. We'll see the
Lordship,
records and
Lordship,
see.
still reasonable that this interim may be granted. Lordship.
Sorry.
So tomorrow is the fixed for,
Is it 376?
yes, Lordship.
No, sorry.
Then Lordship, 2 weeks time may be given.
List
granted.
after 3 weeks. 3 weeks.
Lordship,
376.
by then, Lordship, trial will
Sir,
be, trial will be
376,
completed.
sorry,
Lordship.
sorry. 376.
Reply, right, Lordship.
Yes, madam.
Service report is still awaited.
Offense? What is to be done?
My lord.
What is to be done?
As per the good my lord, the service for, service upon the respondent number 2 is not received, my lord.
Yes. What is to be done?
Still is awaited. Let her take press step. Because this is a POXO case, we have taken a step.
Further, 1 week time is granted to the learned counsel for the appellant to take precise steps for service of notice upon respondent number 2. List after 3 weeks. List the matter after.
Obliged.
My lord, this is a quashing of the complaint
petition being complaint case number 100/2022
Mhm.
filed by the respondent as complainant before the Learned Court of Judicial Magistrate,
Mm,
JMFC UPIA,
mm.
under section 138 of the Negotiable Instrument Act.
Yes.
My lord, the case of the petitioner is that the impugned check was deposited prematurely and without, there is an agreement, and without fulfilling the terms and condition of the agreement, the check was deposited, thereby giving rise to illegal course of action for filing the connected complaint case. My lord will kindly find the agreement at page number 36.
36.
36.
Yes.
This is the deed of undertaking executed between the petitioner and the respondent, proprietor of the respondent. Number one, that the first party, Mr. Kotar Raja, will clear the GST amounting to rupees 9 crore or 9 crore 63 lakhs liable by the MS Kurungkume Enterprises in the execution of the said work. Close to date 9 crore 63 lakhs of 10% GST amount will be 93 lakhs, which is to be paid by the first party to the second party. Clause 3. Further, if it appears the GST of 2% is reflected by the Department Municipal Corporation, the amount to be paid by the first party will be 1 crore 54 lakhs to the second party. Fourth, the said amount will be given by the first party to the second party as and when the pending bill is cleared by the competent authority, that is Municipal Corporation Office of the Itanagar, Arunachal Pradesh. 5, that the first party is issuing two post-dated check number 622623, account number so and so, amounting to 93 lakhs, and check number 6224 amounting to 1 crore 54 lakhs. This is the impugned check. That this amount mentioned is in regard to the first bill of GST incurred upon the Kurungkume Enterprises. My lord, here the check in terms with the clause 5 of the deed of understanding, two checks were issued, and this impugned check was to be deposited only when the 2% of GST is reflected in the Department of Municipal Corporation. However, my lord, they have deposited the check prematurely without there being any reflection of 2% of GST in the department. And in terms with the clause 4, my lord, this amount, this check, impugned check 1 crore 54 lakh, was to be deposited as and when the pending bill is clear from the competent authority, that is Municipal Corporation. But without there being any release of fund, they have deposited. My lord, will come to last page of page number 60 of my annexure.
60.
60.
60.
60. My lord, this complaint case was filed on 22/12/2022. In the year 2022, they have filed this complaint case. And on the request of the petitioner, the petitioner, the IMC authority has issued a certificate showing that no payment has been made as no payment has been released to MS Kurungkume Enterprise after the release of 9 crore 64 lakh due to non-start of the pending work. So prior to release of the fund from the competent authority, they have the respondent, they have deposited the check. And my lord, in their affidavit, document enclosed in their affidavit also says that some payment was made on 6/9/2023 only. That is prior to filing of this complaint petition. And my lord, we have also filed an affidavit showing that the bill was released by the competent authority only on 6/9/2023 and 30/10/2023. This is issued by the Executive Engineer, Itanagar Municipal Corporation, from the concerned municipal department. So here, my lord, they ought not to have deposited the impugned check prior to the release of this amount, because the agreement, in terms of the clause 3 of the deed of undertaking, it was agreed by both the parties that this check has to be deposited only when the competent authority release the fund amount.
What does it say? Where it is?
Clause 3 of the page number 36, page number 37, clause 4. The amount will be given by the first party to the second party as and when the pending bill is cleared by the competent authority.
It's okay, but then clause 5, what does it say?
Clause
The
5,
first party is issuing two checks, post-dated check.
my lord, in terms with clause 5, they have issued the two dated check, and this check was to be deposited only when 2% GST is reflected in the Department of Municipal Corporation, and secondly, only when the pending bill is clear from the competent authorities. So without there being any
Yes.
reflection of.
Yes, my lord. Lordship, what my friend is arguing is all that has to be ascertained by the trial court. The fact remains that Lordship, here,
The record is there. We have maybe also the record.
the fact remains that Lordship, I had given my farm to use, and he had used my farm, and accordingly, Lordship, he was supposed to pay me the GST amount which incurred by him, or in the clause 5 also, Lordship, it says exclusively as when.
Check means post-dated check. And it clearly said the amount will be given by first party to second party, as in when pending bill is clear.
Yes, Lordship. For that reason only, Lordship, we have made an, we kept dark about the payment being made by the municipal corporation, and that in that
According
matter,
to you, they have already cleared the bill. They have cleared the bill.
they have not cleared my bill, Lordship.
No, to him.
That has been clear, Lordship, in that way, like the honorable court wanted us to file and to bring on record, and we have filed an affidavit filed by the respondent to bring on record that amount has been paid to them by the department. Lordship, I'll try to, let me take to my Lordship, affidavit filed by me, Lordship. I'll straightway take Lordship to the page 7, filed by us.
The affidavit.
Yes, Lordship. It's a matter of trial. What he is disputing is
Yes.
to whom it may concern. Lordship, this was issued by the Deputy Mayor, Itanagar Municipal Corporation.
Additional affidavit or what?
Now it's an affidavit to bring on record, Lordship, that a payment has been made to them by them. An affidavit, Lordship,
Yes.
filed by us.
Bring on
Straightway
record.
take to Lordship, page 7, that is annexure A, which we have annexed. It's a to whom it may concern. Given by,
Yes.
My lord,
Is 7 or 8?
it's page 7, Lordship,
Annexure 1.
annexure 1.
What does it say?
It says to whom
It's
it may,
page 8 only.
it's a 7, Lordship, in my affidavit.
Sir, here it is.
Oh,
7,
8, it will be 8, Lordship, sorry.
Yeah.
May I read, Lordship? It
Hmm.
says to whom it may concern. This is issued by the Deputy Mayor. This is to certify that amount of so and so, that is 4 crore 11 lakhs 6,000 has been paid to MS Purunkumet. That is the firm used by by the petitioner through PMS payment number so and so on 6 September 2023. That was the agreement before the date of agreement. And the same day amount of so and so, there is 3 crore. So amount also transferred through PMS number so and so to MS Kurungkum Enterprise. The power of attorney holder, that is,
6 September.
yes.
When did you initiate the case?
We had initiated this case,
22/12/2022.
that it was taken cognizance on 4/9/2023. That is on 9 September or 4 September 2023.
2022.
4th September.
Yeah.
2022.
Hmm.
Payment was made in 6th of September 23.
Yes, Lordship, that's why like before 2023. No, Lordship,
My lord, in this perusal of
Apart
the,
from legality, since you have received the payment, why don't you pay it?
my lord, will pay, but subject to clause 3 and 4.
Lord, that's
But
why
they
I said
have
thi-
initiated this complaint petition prior to the release of this amount.
But issuance of a
And
check.
my lord, this
you
is
have
not
to
a
initiate
legally
check.
enforceable debt. This is a
Sir,
GST
here
amount.
is the admission of on your part that you have issued the check.
My
that is
lord,
not dispute, Lordship.
we have issued the check on the
One
terms
thing is
and
the-
condition
yeah,
agreed.
certain terms and conditions are there, and you have initiated the proceedings before the payment was made.
In my additional affidavit, also says that 2% of the IMC have issued, that 2% of GST is also not reflected. So when 2% GST is not reflected, then how can they deposited the post-dated check? Because it was agreed by both the parties that this check has to be deposited only when 2% of GST is reflected in
the
it.
law? What's the law?
Because my lord, everything arises out of this agreement. And my lord, this is a GST amount. From the day one, we have stated this amount will pay, but they have blocked the GST account. They have not set the password of the GST account. And we have paid them 2 lakh, 50 lakh also to clear the error dues of the GST. But even after paying the amount to open the GST account, they have not opened the GST account. They want the amount to be paid them in case. Because I am liable to the GST department. I am not liable to pay them. Because while purchasing the materials,
Then why-
materials and other items, the GST is included. So I have
So
to
why
upload.
you have to issue the check to the respondent?
My lord, actually what happened in this
If you
case
have
is,
to pay to the department, why you should pay him? Why you should issue a check?
my lord, what happened in this case? The respondent firm was awarded a tender work. Thereafter, respondent has supplied the work to the petitioner.
Sir, I'm not asking you to tell the story. Narrate the story. I'm asking,
Because
if you had to pay the GST to the department, why you have to issue a check for that?
this was issued for a security check. Because in the purse when 9 crore 63 lakhs was released, 10% of the GST amount was supposed to be paid by the petitioner. But due to the error block of the GST account could not be opened, so we could not submit, the petitioner could not submit the input of the bill. So we have requested them to open the GST account. But even after receiving, we have paid them 2 lakh rupees because error dues at that point of time, 2 lakh 50,000, which the respondent have not paid. So we have paid. Even after receiving the amount, they have not opened the GST account or clear the error dues. So this was not paid. So because we could not pay the GST amount because the GST account was blocked. So we have agreed that when the next bill is clear, then we'll pay this 10% of GST amount. So this agreement was entered. My lord, will kindly one affidavit of declaration was also executed between the two parties at page number 38.
38. Yes.
At page number 36, 38, my lord, this affidavit of declaration was executed between the two parties, respondent and the petitioner and the respondent. So this amount was in respect to the payment of GST. So my lord, as part of clause 5, we have issued 2 checks. And when that 93 lakhs was, they in 93 lakhs also they have filed the NI case after the release of the fund. But this 1 crore 54 lakhs was deposited prior to release of the fund. So 93 lakhs complaint case that is maintainable. But here, because they have not fulfilled the terms and condition of the agreement, so the complaint case filed before the learned JMFC court is not maintainable because no criminal offense has been disclosed.
Yes, Lordship. Lordship, in our complaint petition also, we have made an averment along with the documents given by the municipal saying that the running bill was paid to the Kurung Committee, that is to the petitioner. For that, Lordship, in here, in our complaint petition, which they have annexed, it's page 31 to 34, is the running bill given to the petitioner, that is to the alleged accused person. So that's
all after initiation of the proceedings.
no, this is
Because
before the prior.
this amount has, because this total amount comes to 9 crore 63 lakhs and 10% of GST is 93 lakhs. Because this GST amount was not paid because of this deed of undertaking was executed, that on the next running bill, the petitioner will pay the GST amount. But before running bill was issued, they have deposited the check.
That's why also I'm saying this is a matter of trial because before filing of this deed of undertaking between the petitioner and the respondent, deed of undertaking, they had kept us in darkness that no bill was paid to them by the department. And that lordship we have through an RTI, we have obtained that which we have annexed in our complaint petition, the serial number of bill made to them. And then thereafter also lordship, which I have some bring in my record in 2023 also.
My lord,
Payment-
that is
payment
absolutely wrong because if,
That's why
if
lordship,
they are unaware,
Your name, please. Takam Sunil.
T. Sunil.
T. Sunil, learned counsel for the petitioner, and also had Mr. Bijam, learned counsel for the respondent. I'll pass the order.
Lordship, this is a matter of trial. Whether
Pass the order.
no, that's lordship.
My lord, everything arises out of the agreement. And this 93, this was on record from before. If this bill was kept in dark, then how this exact figure is mentioned in the agreement? Because this was known.
Disposed of, I'll pass the order in the chamber. Dispose of,
Yes,
matter is disposed of.
yes, lordship.
You'll get the order by evening or tomorrow.
My lord, this is a passing of FIR application. on the basis of settlement between the complainant.
Yes, who appears for the state?
Just right now, but right now. Maybe possible for time.
What's the offense? What is the offense, sir?
My lord will come page number 19. My lord, this is the FIR, impugns FIR.
19. Yes.
My lord, 7 delegates, this is related to student election. 7 delegates from the Rangpura College, Rangpura Government College, they were coming to Itanagar to participate in the APSU conference come election. And out of 7 delegates, 3 delegates, they were the supporter of the one of the president candidates, Tana Doji Tara. And out of 7, 4 delegates, they were supporter of the president candidate Tagru Tame. So while they were coming toward Itanagar, the team of some member of Tagru Tame, they went towards the they escorted them from the on the way to Itanagar, on the way to Rangpura College. And there, my lord, who was the delegate who was the supporter of the one of the candidate to president, they have informed their general secretary of the Rangpura College, government college, that some some person of Tagru Tame have escorted them.
Have you impleted the impleted respondents, the victims?
Yes, my lord, we have not impleted the victims, but the victims have filed an affidavit saying that since matter is already settled between the complainant, they are no more, they are not, they don't want to pursue the case, and they have no objection if the same case is closed. During the incident, some vehicle was damaged, and both the parties, they have appropriately compensated each other.
All of them are parties here, party here.
Yes, ma'am.
This is what amendment post title you have?
Lordship, here, Lordship, although this
What is
victim
the
parties,
agreement?
that's why, Lordship, in agreement, Lordship, victim parties not been implemented, Lordship.
But they have filed an affidavit saying that.
Lordship, that is their
They are
Lordship,
for that.
and
they are
more
for
of,
victims.
no problem. It's up to the Lordship.
Heard Mr. S. Anything?
No, Lordship, it's up to the Lordship discussion, Lordship. I'm just, Lordship,
You are
whatever.
objecting.
Actually, Lordship, I have just, Lordship, my submission that, Lordship, though victim is made party, but in the settlement, they have not made
He's-
party.
he's
That's
there.
it, yeah.
He is there.
Lordship.
Before
Then I
this
have no
court.
problem, Lordship.
Heard Mr. T. Sunil, the counsel for the petitioner, and MS L. Hage, learned additional PP for state, and Mr. T. Neri. Nega, learned counsel for complainant and the victims. Complainant and the victims. Are they party here? Have they been implemented?
Yes.
Petitioners or respondent? Are they They are respondents or-
They responded.
Okay, respondents. Respondent number. Respondent oblique complainant, informant oblique victim. Petition allowed. Will dictate in the chamber. Will I allow it? First time, where issuing notice? Are you appearing?
I'll be appearing, Lordship, for the respondent. Can it be taken up tomorrow, Lordship? Today I'm filing wakalatnama.
It may be discharged. And let the case be fixed tomorrow for drawing of the substantive questions of law.
Not tomorrow, next week.
Next week, Lordship.
Caveat is there.
Yes, I'm not for the caveat. I'll be appearing for the respondent.
Who is for caveat? Who is for caveat?
They are not here today.
Have you served the copy?
Yes.
No,
I thought-
they are the caveat, respondent number one.
Huh?
They are the caveat.
No, actually what happened, there was a misunderstanding. Since I appeared for the respondent on last occasion, they served the copy to me, but the caveators are my associates, but I did not file the caveat.
Your associate has filed it.
Yes,
On behalf of the respondent number one.
yes,
respondent.
yes,
So,
yes.
heard so and so. Caveat is in the church. List the matter for admission hearing next week, after a week, next week, or tomorrow.
Tomorrow.
Why?
They are trying to evict me. They are trying to evict me.
Thursday. Thursday.
All right.
No, otherwise also on that day will frame the questions.
Yes.
You will come with the draft.
Yes,
Have you given that draft substantial question
Yes,
of law? Yeah.
yes.
yes.
Okay. You also. You also file your draft that thing, questions.
May I also?
Yes.
This is a joint petition filed by the accused and the victim of the instant case, Your Lordship.
Hmm.
Your Lordship, kindly come to the page 15. This is the FIR.
18.
Page 15. 1-5.
Yes.
Yes, sir. This is the FIR, Your Lordship.
Hmm.
The fact of case is that, Your Lordship, this is regarding the dishonor of the check.
Hmm.
What happened on 24th March 2020, a check was issued to the petitioner number 3, who is the victim in the instant case. And the case was bounced. And after more than 17 months, the victim has filed an FIR, report a police station Colorian, and case has been registered against petitioner number 1 and 2 under section 468, 471, 120B and 420 IPC. Your Lordship. And in fact, the deposition, we have recorded the statement of the victim. Kindly come to the page 49, is the deposition of the victim.
49.
Yes, page number 49.
Hmm.
May I, Lordship? I have come today to court on receipt of summon from the court. I can identify the accused person standing on the dock today. Their name are Bengia Pacha and Pantapo. Accused Panitapo is the proprietary of Miss Baby Enterprise, who was awarded tender for construction of approach road from BRTF road to Tayang Place under the scheme SADA 2018 and 19. He could not finish the construction of the above and approached me to complete the said work, and accordingly we enter into a power of attorney agreement dated 16/01/2022. And during the cross, Your Honor, kindly come to the next page, that is 50. I have relied the letter of authorization which the victim is stated before the court. Kindly come to question number 3, crossed by learned DC. Learned DC has relied on the letter of authorization which is marked as exhibit P exhibit 2 and the witnesses read out the content of the P exhibit word. Is there any word whereby you will authorize to complete the tender work? No, Your Honor, there is absence regarding the tender work. And in question 4 also, question 4, do you have any other document other than the letter of authorization whereby you were asked to complete the said tender work? No, Your Lordship. In fact, during the check was bounced, no any legal notice has been issued from the victim. He also admitted in this question number 12. Question number 12, Your Lordship, I have. Did you
said,
send?
you have compromised?
Yes, Your Lordship.
Huh?
Yes, we have compromised.
Where is the? Where is
In Annexure G, page number 54, Your Lordship.
84.
54, 54.
54.
Lordship, I have, this is the original settlement deeds I got.
Juanita Po
Yes, Your Lordship.
and Srimati Yumlam Sarne.
Yes, Your.
Huh?
Yes, Your Lordship.
He's the complainant.
Yes, Imam Sim is the complainant.
Proceedings is under 138. No.
No. Even Your Lordship, there is a specific limitation regarding 138. It says within 6 months you have to.
No, that's what I'm saying. Whether the proceeding is under the 138
No,
NI
no.
or it's in
Only this is a criminal case has been initiated against the accused person only.
not under 138.
No, no.
Okay.
Your Lordship, even in the letter of authorization, that is in page number 38. Page number 38. There is also nowhere mention that the victim should carry out the work, Your Honor. This was issued only to participate in the tender proceeding. It's clearly mentioned there, Your Lordship. May I ask? I, Sri Pani Tapos, on Pani Rui, proprietary of Miss Baby Enterprise, Blaze Goose, POPS, Coloring District, Kurungkume, Arunachal Pradesh, do hereby constitute and appoint Mrs. Yumlam Seme, daughter of Yumlam Taung Blaze, Yumlam POPS, to represent on behalf of my firm and authorize her to purchase, submit tender paper, and initial signatory participation in the tender process on my behalf, Your Lordship. Whereas in his deposition, the victim is clearly saying that he was engaged to finish the remaining work. 49 deposition, Your Lordship. In middle part, she is saying that accused could not finish the construction of the above work and approach me to complete the said remaining work. And I enter into favor of authorization. But letter of authorization, there is no word mention to carry out the work. It's simply issued to the victim to participate in the tender proceeding.
This petitioner number 3, who is 4 and 5 are?
4 and 5 are, 5 is the husband of the victim, who is the concerned JE of said project.
They are the complainant.
Yes.
They are the complainant.
No, they are witness, prosecution witness, Your Lordship.
Huh?
They are prosecution witness.
So why they are to be party before this?
You know, since he is the husband of the victim, you know. In fact, he was the site JE, PWD JE.
They are not the complainant.
No, Your Lordship.
Why should be there? 4 and 5?
Four is complainant here also.
3
Three is also complainant.
and 5?
Five is, no, that is prosecution witness.
Why it should be party? Then
Yeah.
it's 1 and 2
One and two is the accused.
accused person.
Yes, Your Lordship.
This is GR case, its matter is pending.
Pending
Charge sheet has
before,
been filed.
yes, charge sheet has been filed and the trial is under trial.
Trial is going on.
Yes, going on.
Where did you file this affidavit? I mean, the petition?
Petition on 5th June 2024. 5th June.
5th June.
Yes.
Yes.
Your Lordship, just I rely on one of the judgment in Lakshmi Narayan cases. Relevant portion is 13, para 13, Your Lordship. Since
13,
the,
13
yes,
or 15?
13.
This is what is the citation?
Yes, citation, Your Lordship.
What is the citation?
Citation is saying that if the party mutually settled, where the offense is not a heinous offense.
Huh?
Heinous offense, Your Lordship. Since my, whatever the charges section is less than 7 years, punishment is. And in fact, when we see the section, Your Honor, 468 says about forgery for purpose of cheating. And 471 using a
Yes.
genuine force. Yes.
Yes, these offenses can be compounded by with the consent of the court if parties arrive into the settlement. And this is a monetary transaction between the parties. And there are two FIR against the two accused. So complainant and even authorities who awarded tender has also become a witness to the settlement agreement. So since there is a settlement, so any appropriate order may be passed.
Had Mr.
P bate.
Huh?
P bate.
Learned counsel for the petitioners and also had Mr. Jita, learned additional PP for his state. Next paragraph. By filing these application under section 482 of CRPC, 1973. The petitioners have jointly prayed for washing of. What is the JR case number?
GR, GR 33 of 21, 2021.
JR case.
Yes, GR case number 33.
Where do we get it?
In a prayer portion, last
You are not given in the.
page number 12. In last entry part here also.
Quashing of the criminal proceedings of GR case number 33 of 2021 under section 468, 471, 120 within bracket, capital B, bracket close 420 IPC, 1860. On the basis of the settlement between the petitions. Next page. Next, the case in brief is that an FIR was lodged on 14/08/2021 by petition number 2 and 4 against the petitioner number 1 and 2.
1 and 2, 3 and 4 is there.
Alleging that the petitioner number 1 being the proprietor of Messrs. Baby Enterprise, who had been initially authorized for petitioner number 2 and 3. No, 1 and 2, 2 and
Yes.
3, 1 and 2,
Yes.
1 and
One
2 to bid for a tender on behalf of on their behalf, with a condition that whoever wants would carry out the work. Does not carry out the work, to execute the work, and the petitioner who participated on behalf of Messrs. Baby Enterprises had for construction of approach road from BRTF road to Tayang under PWD, under Sangram PWD division in the district of Kurungkume. For an amount of rupees 96,06,200, rupees 96 lakhs 8,200. The petitioner number 2 has asked for sharing in the construction of work with the petition number 2. With the on the denial of petitioner number 2. But the petition number 2 has started the work on the same stretch of road. And upon completion of the work, the payment was released against the petitioner number 1. Farm, i.e. Messrs. Baby Enterprises. The disputes started with regard to payment of the payment in between petition number 2 and petition number 3, whereby petition number 1 has issued a check to both of them. However, the check got bounced due to insufficient fund. Mr. What is the FIR?
FIR is page 15.
15.
Yes, page 15. 1-5.
two FIR.
Yes. Page number 17.
List of the two FIRs.
Yes, yes.
No. The petitioner number
3 and 4.
three and four
Yes.
have lodged two FIRs on 14/08/2021 and 18/08/2021. Alleging that the petitioner number 1 and 2
Yes.
have made illegal transaction and using by using false documents with regard to the pending bill payment of bills
59 lakhs.
huh?
59 lakhs 25,000 is any or FIR.
Okay. Against the petitioner number 1 and 2. Stop. Accordingly, when it was registered
This was registered on
receipt of the said FIR, above mentioned FIR, case being coloring PS case number 17 of 2021. Under section 468, 471, so and so, that's same. Was registered. Upon completion of the investigation, a charge sheet has been filed against the petitioner number 1,
1 and 2.
1 and
Yes.
1 and 2,
1 and
1 and 2, which is pending trial before the London Judicial Magistrate First Class Colonial, being JR case number 33 of 2021. What is the stage?
Evidence. Evidence. Yes, prosecution witness.
Mr. So and so, learned counsel for the petitioner. Petitioners submits that during the pendency of the trial of the case, the parties have entered into an agreement. Where is this? Where is the agreement?
Agreement is in page number 54.
54.
Yes, 54, 54. 7 May 2024.
Entered into an agreement, particularly between petitioner number 3 and petitioner number 1 and 2, whereby the parties have resolved the disputes and to disputes amicably as the FIR was lodged as the matter relates to a transaction of a business transaction with regard to regarding execution of construction of road, is it?
Yes, road.
Construction of road pursuant to NIT. He submits that the FIRs were lodged by petition number 1 and 2, 3 and 4 due to certain misunderstanding, and by now the parties have settled the matter and decided to maintain cordial relationship among themselves. Next, Mr. So-and-so, learned counsel, further submits that, further submits, while referring to the evidence, particularly cross-examination of the petition number 2, the petition number 3, submits that as per the records, no offenses made out against the petition number 1 and 2. Therefore, apart from therefore, the present the criminal proceedings being GR case number 33 of 2021 under 6 pending before the learned magistrate, judicial magistrate first case following may be set aside, may be quashed. Next bill. Mr. G. Taro, learned additional PP, in his usual fairness, submits that the case arises, a case relates to business transaction between the petitioners which may not be an offense against the society. Therefore, the petitioners have voluntarily settled the matter by executing a deed of mutual settlement among between them, amongst themselves, among the petitioners. In such, in view of the above, in view of the facts and circumstances of the present case, he submits that an appropriate order may be passed by this honorable court. Thanks. Due consideration has been extended to the submissions of learned counsel for the parties, and also there is the records. Where is the records of trial court? is not next para, as noted above, two FIRs were filed against by the petition number 3 and 4 against the petition number 1 and 2, alleging certain illegal transaction as well of illegal transaction by using forged oblique false documents, which relates to issuance of check as well as check and the payment thereof for the execution of contract work on behalf of the firm of the petition number 3. Petition number 3, right? She is the proprietor. Petition number 3.
This is the victim.
Who is the owner, proprietor of the farm?
Petitioner number 1.
Number 1. Okay, this is the farm MS Baby Enterprises.
Yes, maybe interface.
List of the work contract relates to construction of road from BRTF road to Payam under the scheme of SADA SADA 2018 to 2019 under the Department of Public Works, Sangram Division. List of the list. Undisputably, the matters relates to a business transaction in the course of business transaction relating to payment and issuance of the check, as well as issuance of check and payment thereof. Mr. On perusal of the record, it is revealed that no prima facie case under section so and so, all those sections appears to have been made out, although the charge sheet has been filed against the petition number 1 and 2. That apart, as per the deposition of the respondent number 3, petition number 3, particularly in the cross, this no case could be even prima facie established against the petition number 1 and 2. There is also notice that the parties during the pendency of the GR case, criminal proceedings in the present case, the criminal proceeding of the GR instant case, the parties have entered into a settlement by dated 07/05/2024, without there being any coercion from any angle, rather a voluntary settlement to maintain cordial relationship in near future, in future among the petitioners. Please do. Next paragraph. It would be apposite to refer to the law laid down by the Honorable Supreme Court in the case of that Lakshmi Narayan, State of Madhya Pradesh versus Lakshmi Narayan and others reported in so and so 2019 something, huh? 19 so and so. You find out, huh? Wherein the Honorable Supreme Court, after considering the law and other decisions of law and law in the after considering the law and also earlier decisions on the point, has observed that the power conferred under section 482 of CRPC to quash the criminal proceedings for non-compatible offences under section 320 of the court can be exercised, having overwhelmingly and predominantly the civil character, particularly those arising out of commercial transaction or arising out of matrimonial relationship or family disputes, and when the parties have resolved to enter dispute amongst themselves. Next slide. Having considered the materials and submissions of the learned counsel to the parties and also the materials placed on record, coupled with the deed of settlement, the deed of mutual settlement dated 07/05/2024 between the petitioners, amongst the petitioners. No, between the petitioners. Come on. I am of the considered view that the present case is one of the cases where the inherent power of this court under the 482 of CRPC can be invoked accordingly. No, Mr. Accordingly, the criminal proceedings of GR case number 33 of 2021, pending under section so and so, pending before the London Judicial Magistrate Prosecutor's Korean is hereby set aside. The criminal petition stands allowed and disposed of.
Much obliged.
You just
It's for hearing lordship.
Lordship, here, respondent number 2, the service is completed, Lordship. Lordship, so it may be paused for hearing.
Lordship, the only section is criminal trespass lordship. Here lordships, petitioners is having a allotted plot of land lordships. FIR is lost by deputy commissioner lordships, capital complex, Dishonored lordships. Yes, no other than lordship.
Because
What the party? Given lordship.
First week of December, Lordship.
Up to 2 weeks, lordship. If lordship, next week lordship. No lordship, next week lordship, we are ready lordship. Not today lordship.
Right.
Information.
Right.
One second.
May I beg your lordship? Pre-arrest bail. Your lordship, CD was called for on the last date, your lordship.
CD here, Lordship, but in the CD, Lordship, Lordship, it is revealed that, Lordship, last occasion, Lordship, this accused was granted interim protection, Lordship. But in the CD, it's reflected that accused has prayed before the Honorable Court that his statement already been recorded, Lordship. On that basis, the interim was granted. But here, Lordship, in the CD, it's reflected he has never appeared before the IO, Lordship. So after the issuance of the notice under section 35(3) BNSS. So the case was registered on 17/10/24 and notice again issued on 18/10/2024, Lordship. And then after granting that interim protection, then he has appeared, Lordship. So he has misled the court, Lordship, on the first day, Lordship. That is their, Lordship.
468, your lordship. 468. Forgery. Yes, your lordship. Forgery, your lordship.
Lordship, here, Lordship, this allegation serious, Lordship. As per the Lordship statement, Lordship, he has admitted that he has done that, Lordship, forgery. But the Lordship, this document, Lordship, he's not revealing, Lordship, where the documents are whereabout, Lordship.
The custodial interrogation is not required.
Yes, your lordship.
Lordship, is this, Lordship, actually, Lordship?
Direct the condition that he, as and when it's required, he should,
Yes,
he should appear.
Then, Lordship, then he may be, Lordship, strictly, Lordship, to be,
Any terms and conditions.
Lordship, cooperation with the IO and that, Lordship, his,
Where it is, where it says.
Lordship, his statement is there, Lordship.
It is to be noted that the statement of alleged accused is inconsistent, does not corroborate with any of the witness. The alleged accused has also denied about whereabouts of the original death certificate of the late person Meteor. Has not been arrested and released in good health before he is arrested. This is when, after this?
After this interim granted, Lordship.
Hmm?
After the interim protection was granted, the earlier, Lordship, they have misled the court and misinformed the court that they have already recorded the statement. That is not there.
Better allegation is perjury, but that has no going to, I mean, all this thing. But
Yes, Your Lordship.
don't try to play with
Your Lordship,
the
this
proceedings.
is the statement of the IO, Lordship.
Huh?
This is the statement, this is what IO stated.
Why are you to
Yes.
investigate?
Your Lordship, when I went for executing the order of this honorable court.
Are you disputing seriously?
No, Your Lordship. I take back my words.
Let there be a proper investigation.
Yes, sir.
Just because allegation is
appeal.
perjury may not be, the custodial interrogation may not be required, therefore, when granting,
Yes, sir.
make it absolute, with same terms and conditions.
Yes, sir.
Heard Mr.
Teasering, Your Lordship.
This is learned counsel for the applicant, and also heard MS L. Hage, learned additional PP for the state. This is an application under section 482 of BNSS 2023. Praying for grant of privilege of pre-arrest bail to the accused applicant, Sri Tapimaki.
Tapamaki.
Tapamaki. List of. Where's the FIR?
FIR is, Your Lordship, page number 13, Your Lordship. This is the written complaint, which was registered on 17/10/2024.
Where's the allegation? And a written complaint has been filed, was filed before the officer in charge, police station Thalia, by one Sri Singde Niagio,
Nyagio, Your Lordship.
Nagio,
Yes, sir.
Niagio, page 14. Against the accused applicant, alleging perjury of documents, alleging perjury, alleging perjury of the signature and seal, signature and seal of the office. Mr. It is when alleged that the accused applicant has said person means who? Do against you only,
Yes, sir.
No person. Only one accused.
as has obtained death certificate of late person Niagio on 12/07/2021 from Dalia sub-register, who is not competent authority. Competent authority without the knowledge of the deceased persons actually against the deceased person's family relative, including the wife, sons and daughters, and cousin brothers, etc. It has been further alleged that the accused applicant has misused the death and birth, misused the death certificate, which has been obtained from the death and birth statistic department at Daporizio. And also a death certificate obtained from Gampura. And also death certificate for appointment of Gampura. Accordingly, an FIR was registered, accordingly, a case was registered being. What is this FIR? Talia Police, PS case number
Earlier PS.
07/2024 under section 468 of IPC. 1860. Who are you?
Your Lordship, I'm an elder person who applied for the post of counter way back in the year 2022. Subsequently, this complaint came in the year.
You have been appointed.
My name was recommended.
No,
Subsequently,
you
in
are
the year-
yet to be appointed.
Yes, sir.
Okay.
However, Your Lordship, now it is cancelled, Your Lordship.
Hmm?
However, that thing is also cancelled, Your Lordship, as of now, pursuant to this complaint.
This is the only thing. Yes, madam.
Lordship. Lordship, as per this FIR, Lordship, it is pertaining to that this alleged accused is not belong to the Negio village, is not right to apply back in
It's
Gambla
a-
post.
It's
investigation,
an
Your
FIR only,
Lordship.
but you have admitted.
But it is, that is, yeah, Lordship, he is already admitted and that Lordship, the
Except
document is
he
still
had
with
indeed
him.
issued the death certificate of late Persing Niago. But it is similar, he cannot remember.
Or maybe strict term and condition may be imposed,
Yes.
Lordship.
On the appraisal of the court, it is seen that the accused applicant has accepted that he had issued the death certificate of one late, of late Persing Niago. However, he has stated that Persing however, considering that the offense relates to allegation of forgery, I'm of the view that the custodial interrogation would not be required in the present case, as the petitioner has given his statement before the investigating authority. Having considered the materials placed on CD and also considering the facts that the petitioner has been the statement of petitioner has already been recorded along with the other witness and also the other witnesses. I deem it appropriate to allow this present application. Accordingly, the accused applicants accordingly, the interim bail,
Yes.
the pre-arrest bail granted when it was
6/11/2024. 6/11/2020.
6/11/2024 by this court is made absolute, huh? Yes, sir. Made absolute with the same with the following condition. What is the condition?
Condition was that the lordship, I shall cooperate.
Wait,
the-
same. Absolute with the same terms and conditions. As in when?
Yes, sir.
You cooperate, you don't try to play with the authority.
As and when call for lordship.
As in when,
Yes.
same terms and conditions.
Lordship.
It's here.
Highly obliged.
Obliged, lordship.
Yes, sir.
May I please
What is to be done? Service
here-
report not yet received. In
Yes.
respect of respondent number one.
Step is already taken, but still report
Okay.
is awaited.
Had Mr. D. Bose, London Council for the petitioner. Appellant, right? Appellant. Office note dated 16/11/2024 reflects that service report in respect of respondent number one is yet to be received. This is accordingly. Awaiting service reports, this after 3 weeks. List,
Lordship, there is an interim order also.
awaiting, service, awaiting service upon respondent number two for further 4 weeks. Come on, list this matter after 4 weeks. Interim order pass earlier shall continue.
Highly obliged.
My lordship.
Yes.
Service reports against private respondent of assault respondent lordship.
Hmm.
Awaited lordship.
Heard Mr. G. Bam, London Council for the petitioner. Petitioner or what?
Petitioner.
Petitioner.
Only one.
In view of the order, the office order, the office note that is 16/11/2024, reflecting await of service report upon respondent. Come on. Let the matter be listed after awaiting further 4 weeks. No, list the matter after 4 weeks. List them. Huh? Interim order pass earlier shall continue. Well, this sir. What is IA? IA for what? IA is for what? Hmm?
Well, I think this is item number 18.
18, Your Honor.
18.
Okay. Yes,
You know, we shall take fresh steps, Your Honor. By justice service, Your Honor.
you,
Yes, Your Honor.
okay.
Upon respondent number 2.
Mr. No, Mr. M. Partin, learned counsel for the petitioner.
Yes, Your Honor.
Is granted for that, granted a week's time to take fresh steps upon respondent number 2. Is the as office note dated 14/11/24 indicates that the service is yet to be, a service report in respect of respondent
By dusty,
is
Your Honor.
yet to be received.
By
List
dusty service, Your Honor.
Mr. The Dalal Council to the party may no, that take steps for service of notice by dusty mode, huh?
Much obliged, Your Honor.
That what I'm saying, Mr. So is granted for that, granted for 7 days, a week's time to take fresh steps by your dusty service upon responding. By dusty mode. Yes,
May I please, ma'am?
yes.
My lord, this I is for implementing the private respondent, my lord.
Will allow this.
My lord,
Will allow or will issue notice?
my lord, it can be, yes, it can be allowed, my lord.
Hmm.
It is just for implement, my lord. In fact, it pertains to the PDS case. Implement.
Yes, no objection. Huh? The, heard Mr. Opada, Leonard, special PP.
My lord.
For SIC. Special PP, SIC, huh? And also heard Mr. H. Lampu, Learned Council for the
Respondent number 8.
respond number 8.
My lord, I am got respondent number 3 and 6.
You right? For Mr. So-and-so, 3 and 6,
And for respondent number 16 and 7.
16 and 7. Yeah. Next to that. Okay. By filing this application, the applicant had prayed for implement of one city, Likatakam,
Likatakam, my lord.
who is stated to be, who is serving as, who was
Yes, my lord.
serving as LDC in the office of the what circle officer, Pipu, East Coming District, Arunachal Pradesh. Is party respondent in the connected criminal appeal number 20 of 2023. Having considered the grounds for implement of the above mentioned person, namely Sri Likataka, and also they have not been objected to they have not been opposed by the Learned Council for the respondents, I deem it appropriate to allow this application. Accordingly, the Sri Likatakam is no more working.
No, he is not working.
He's not working now.
He is not working.
Likatakam.
No, my lord, I don't have any instruction on that, my lord, but then
Anyway, Likatakam. Address, where is his address?
address I have given in coast title, my lord,
Where it is?
at page number 7, my lord. Likatakam late Likatechi, resident of deed, POPS Rejali, K Panjaro district.
Son of late Likatechi, resident of deed,
My lord.
POPS deed. PO deed, police station, PS Yazali, district K Panjaro, Arunachal Pradesh. Be pleaded as
My lord, in my prayer, I have written as respondent number 5, my lord.
respondent number 5.
In place of Vijay Gupta, my lord. In fact, during the filing of
Anyway,
this,
cannot delete that. As respondent number 5. No, we cannot just delete, we'll make him respondent number.
why? Because, my lord, there were 17 accused persons, my lord. But during filing of this instant,
We'll make him
appeal, my lord,
18.
the Vijay Gupta's name came twice, my lord, in place of Likatakam, my lord. Inadvertently, my lord. My lord.
As respondent number 18.
My lord.
The highest instance allowed and disposed of.
Oblige.
We'll finish their orders. 21? 21 also. What is 21? 21? This is for what? 21? Them.
No, 21 is for condonation of delay, my lord.
Huh?
Condonation of delay, my lord.
Acha. We'll have to issue notice.
The already notices have been issued, my lord, but I have to take fresh steps on other respondents, my lord.
Learned special PP SIC is granted a week's time to take
My lord, my lord.
upon all the respondents,
Not all the respondents, some of the respondents.
take steps upon respondents.
Oblige.
This after 4 weeks.
All right.
Why this? What is IA? IA
For substitution of the respondent two, my lord.
Ah,
And then my friend has come with an order, my lord. SLP, my lord, they have preferred an SLP.
what is this? Then why this has been listed?
Well, I have filed an IA, my lord. For substitution of respondent number two, because respondent two has expired, my lord.
Pending before the court shall remains listed. So
Yes. Today they have, my lord, apprised us.
in view of the order passed by Honorable Supreme Court in the in SLP in petition for still leave to special leave to appeal number 25467 of 2024 within bracket Rajan Muley and another versus Bitukri and others bracket close. The proceedings of the first appeal number 03 of 2020 shall remain shall not be proceeded further now till the municipal court. No, shall not be proceed further. Shall not proceed further.
May I please? My lord, I prayed that, my lord, in item number two, my lord, registry may be directed to return the wakalat nama.
Why?
My lord, it is difficult. my
When
lord.
the stamp is taken, it's with. Can you do that? Can the wakalatnama be returned?
Last occasion, my lord, Justice Mehdi is directed in one case, my lord.
Any order passed? Any order has been passed or what?
Yes, my lord, order was passed, my lord. But I forward the exactly case, my lord.
You find it out and give it to. So.
May your lordship.
My lord, otherwise, my lord, I may be allowed to amend the course that my lord.
No, you can, once we pass and all this, can.
Yeah.
Again and again.
Your lordship, item number 25, your lordship.
Yes.
This is criminal appeal, your lordship.
Yes.
For the respondent number 2. But here for the appellant, counsel for the appellant amicus, Mr. Tison has called me that he is not available today, so this matter may be mentioned.
On the prayer of Mr. T, sir, learned amicus curiae. And MS and learned legal aid counsel. Let this matter be listed after 3 weeks.
Lordship, obliged.
My lord, I'd like to mention item number 28, my lord.
Huh?
28. My lord, this matter may be.
We'll see it too. We'll see it too.
Okay, much.
Petitioner, leading counsel, he is an out of station, so he cannot appear today. The kindly the matter may be fixed on 17th December.
On the prayer of learned counsel for the appellant, list this matter on 17
December.
12, 2024.
Must be.
No, please, boss. No, this is a jail appeal. This appellant was convicted on the 6th of October. Yes.
This is a contest case. Private respondent is absent today.
On the prayer of Mr. A. Bhattacharya,
Yes.
on the prayer of Mr. I heard Mr. H. Lampu, Lamit Constable, Lamit London Americas. And also heard Mr. T. Jita, London people. Mr. Since Mr. Arup Bhattacharya, A. Bhattacharya, London Council for respondent number.
Respondent two.
Respondent number 2. Is not present. Since Leonard, since Mr. A. Bhattacharya, Leonard Council for respondent number 2. Is stated to be having indisposed today. Let this matter be listed after 3 weeks.
Problem.
This is joint application filed by the petitioner and the victim and the complainant.
You want to take the time?
Yes, madam.
You are asking for adjournment.
Earlier, yes, madam, I was asking for the adjournment.
Huh?
Earlier, I was asking for the adjournment.
When do you want?
21st of this month.
21st.
Yes.
21st is it's not a holiday.
No.
Saturday.
21st is 21 month. This month, man.
Okay. On the prayer of Mr. The other council for the petition list is made on 21/11/2024.
Yes.
Miss Miss Ella Hagen please.
Madam, there is the interim.
Interim order pass earlier.
Yes.